The next section is, ironically, the most heavily tested section. I mean, formation, revocation, but the most heavily tested topic is in this section. And I want you to look at the name of what it's called. Unintentionally omitted family members. And this is the key word, unintentionally. It's like, oh, darn, I forgot to provide for my kid or my wife. And here's the situation where omitted or pretermitted child comes into play. By the way, the word pretermitted means omitted. It's the exact same thing. It's like saying subsequent and after. So don't rack your brain on that. And if you didn't know that after all these years, you should have looked it up a long time ago. So here's the typical scenario. This is how it occurs. The testator makes a will. See, I'm single, don't have any kids right now. I'm the happiest guy in the world, by the way. So just put that aside for a second. But let's just say sometime later I do have a kid and I forget to amend my will. Whoops, forgot the kid. That's an omitted child, or you can also say pretermitted. Like I said, the words are used interchangeably. They mean the exact same thing. So an omitted child is a child who's born or adopted. Adopted children are treated just like regular children, not stepchildren, not the redheaded stepchild that you accidentally don't want in the family. I get that. But a child that's born or adopted after the execution of all the wills, the child's entitled to the intestate share. So if the decedent fails to provide for a child born or adopted after the execution of all the decedent's testamentary instruments, the omitted child receives her intestate share. The statute is designed to protect children from being unintentionally omitted from the testator's estate. You have to imagine that this happens so often, where a single man creates a will. It could be a single lady. I'm just using me for the example. A single man creates a will, then he has a child. The child's born or it's adopted. You can adopt the child. After the execution of the will, you forget to amend your will because you're so busy taking care of the child. Something happens to you, you pass away, and now the statute protects the child, so the child's not left with nothing. The child gets the intestate share. Now, you're most likely to be tested on the exceptions. And the exceptions are, an omitted child does not receive her intestate share if any of the following are established. Number one, the decedent's failure to provide for the testator was intentional, and that intent appears on the face of the will. That means literally the will must say, I do not want to provide for my bastard son, or whatever the case is. You have to intentionally say on the face of the will, I don't want to provide for my child for whatever reason. Like, I don't know, let's say you're one of the Lyle and Eric Mendendez, whatever, you know what I'm talking about. Like, had they known, they would have excluded them. Of course, the Slayer statute kicked in. So the intent appears on the face of the will. And the most likely one that you're going to get tested on is this one. When the decedent had one or more children and devised substantially all, I'm assuming that's probably going to be around 80% or higher. Substantially all of the estate to the omitted child's other parent. So let's say that I have a will. I get married to, who was I dating before? Jessica. And we have 2 kids together. And I never changed my will. Me and Jessica get married. We have no kids. I create a will. I give everything to Jessica. Then except for a few little odds and ends there, like 10% of my estate, I give to a couple of my friends. Jessica and I have 2 kids together. And when I die, let's say I die, and I don't ever change my will after I have the 2 kids. Well, the kids, although they were born after the execution of the will, they get their intestate share, except if I left substantially all to the kid's other parent. And who would be my children's other parent? My wife, Jessica. So because she's getting 90% of my estate in my example, the omitted child statute will not take effect because the exception applies. On an essay, you do have to discuss this and go through it. So the decedent had one or more children and devised substantially all of the estate to the omitted child's other parent. Or, number 3, the decedent provided for the child by transfer outside of the will, and the intention that the transfer be in lieu of a provision in the will is shown by statements of the decedent. Usually, like I say, I don't provide for my child is provided for because of see this bank account, or this trust account or this stock account, this brokerage account. And it says, so it's shown by statements of the decedent or from the amount of the transfer. So again, take my net worth, $5,060,000, and I put a trust fund for my child for $4,600,000. Now, and I don't write anything in my will. I don't even have a will, let's just say. So I provided for my child, and this is a trust fund for my kid. So you can go to USC and hang out with all the other trust fund babies. Transfer outside, I went to SC, easy there. Transfer outside of the will, and the intention that the transfer be in lieu of a provision in the will is shown by statements of the decedent and by the amount of the transfer. I think this pretty clearly signifies that I didn't unintentionally provide for my child, that I intentionally provided for my child by a transfer outside of the will. I gave him a trust fund, or let's say I put it in a bank account or a stock account, whatever have you. So that's how you determine whether the transfer was outside the will. So that's omitted child. It's actually the most important, or excuse me, the most heavily tested topic in wills, which again by default would make it the most important because you're highly likely to see it. Now, in conjunction with omitted child, there's the unknown child, or a child believed to be dead. For my situation, it would probably be unknown child. So I would be unaware of the child's birth. Let's say that a few years ago, I knocked somebody up that I didn't know, that she never told me about it. And years later, I find, I end up dying. Of course, I'm not going to provide for that kid because I don't even know the kid exists because she never told me. DNA test later proved that I am the child's father. So either you believe the child to be dead or you're unaware of the child's birth, intestate share. Okay, omitted spouse, very similar to omitted child. So what happens here is when you get married after you execute the will. So in my example, I create a will. I'm a single man. I create a will. Then I marry Jessica. And we get married. After the execution of my will, I never provide for Jessica. So the testator's will fails to provide for his spouse, whom he married after the execution of his final will. The omitted spouse receives all the community property. That makes sense. All the community property. It's half hers anyways. Why not give it to her all when I pass away? Because my will doesn't say anything about her. So she gets all the community property, and then she gets her intestate share of the separate property, but only up to 1/2. There's no easy way that I can think of remembering that. In fact, I just had to read it to understand it again, or to remember it again. So an omitted spouse is somebody who's married after the execution of the will. She gets all the community property, and she gets her intestate share of the separate property, but only up to 1/2. So what that means is at least 1/2 of my separate property are going to go to my other friends and family. Probably most of my other family, my brothers, my mom, my dad, whoever else. Okay? And the exceptions are almost the same as the omitted child. Now don't forget, these statutes are designed to protect spouses and children from being unintentionally omitted from the testator's estate. So, when does the omitted spouse not receive her intestate share, which means all the community property and then her intestate share of the separate property? Number one, where the failure to provide for my spouse was intentional, and that intention is shown on the face of the will. Same thing with the child. I got to be honest with you. Why are you in a marriage if you're intentionally excluding your wife? You should probably thought about divorce a long time ago. Probably it's not something I would ever do. Number two, the decedent provided for his spouse by transfer outside the estate, and the intention that that transfer be in lieu of a provision in the will is shown by statements of the decedent or from the amount of the transfer. Where have we seen that before? Notice that this is there and this is here. So the two exact same exceptions for omitted spouse and omitted child. The only other exception for omitted spouse is when the omitted spouse made a valid agreement waiving the right to share in the decedent's estate. And what are they getting at? Prenup. She signs a prenup, which we're going to get into in just a second. So you can't be an omitted spouse if I made you sign a prenup because my intent was for my property to stay my property, your property to stay your property. I don't care if I marry Oprah. We keep our stuff separate. Simple as that. Okay, moving on. Waivers. There are two types of waivers. One that I almost never have heard of, inheritance waivers. The more common one, the premarital agreements. Let's just knock out the inheritance waiver. It's just a waiver of your inheritance rights. It must be in a signed writing. The decedent must provide a fair and reasonable disclosure of his property prior to the signing of the waiver. So essentially I say to my spouse, here, this is what you're giving up. Like, I want all my property to go to all my family, other family members, my brothers, my sisters, they're my cousins, my nieces and nephews, and I don't want you to have anything when I die, because maybe she's old too, or maybe she comes from a wealthy family, or whatever the case is. So it would be a signed writing disclosing all my assets so that she knows what rights she's giving up, and she's represented by independent legal counsel. Now, the court's going to, despite even these requirements, a waiver is still going to be enforceable if the court determines that it was fair and reasonable. So if we have a signed writing and I don't disclose my assets or she's not represented by legal counsel, as long as it's fair and reasonable, the court's going to be like, that's okay. That's the inheritance waiver. That means the wife signs off and doesn't get anything when I die. Look, the concept's been tested once in the last 20 years. That's how much time you should spend on it. Okay, now premarital agreements. The key is they must be voluntary. And what's the definition of voluntary? Here's how you're going to remember it. It's going to be real easy. For those of you that follow baseball, Florida Marlins hitting coach, also played for the Pittsburgh Pirates when he was coming up, most notably his time with the San Francisco Giants. I'm talking about Barry Bonds. Barry Bonds, when he was at the start of his career, he was doing well. He married a Swedish girl. And here's the scenario how it happened. And think about this story, because this story is going to make, this is exactly how I remember the law. And for anyone who ever read this case in law school will understand it. Remember how I said Gunnarson's the one who made the statutory, like the Gunnarsson example, the lawyer Gunnarsson, who was ripping off people at Leisure World. What he did created the statutory presumption of undue influence. Well, Barry Bonds created the statutory premarital agreements and why they must be voluntary. So Barry Bonds was dating this Swedish girl. This is a key reason why I say Swedish girl. And they got on a plane to go to Vegas one weekend. And while on the plane, as they were flying to Vegas, he says to her, let's get married. That's what you do in Vegas. You do crazy things. So this is the day before they get married. And they're in the plane on their way there. And he has her sign a premarital agreement saying, oh, she's not going to get any money or any property, anything like that. And she signs it. Think about this. That was actually considered valid because the statute hadn't come out yet. The statute is now here. So, all of the following must happen for it to be voluntary. Don't forget, she was with him on the plane going to Vegas. So she didn't have the opportunity to seek independent legal counsel, and she didn't expressly waive her right to seek independent legal counsel. So, like I said, they were together. It was only them. He kind of isolated her. They were on the plane. What's she going to do? She's going there with the guy she loves, the guy she likes, or lusts, or likes his money, however you want to phrase it. And she signed it a day before. So the statutory requirement says you got to give her 7 days before she signs the premarital agreement. Also, if the person who's signing the agreement is unrepresented by legal counsel, that party must be fully informed of the effect of the agreement as well as the rights she's giving up by signing the agreement. So what that means is you have to tell her what your net worth is. Fully informed of the effect of the agreement. What this means is I'm worth $5 million. Guess what? You ain't getting shit. That's essentially what this element is. It's the rights that she's giving up. You're not getting any of my money. So how eloquently you want to phrase that, look, let's be honest, let's cut to the chase. That's what it means. Number 4, the waiving party must be proficient in the language in which the agreement was written. Well, she claimed, and the court may or may not have bought it, but now the legislature said, wait a second, that makes sense. Hey, ironically, about a year and a half ago, I was dating a Russian girl, and her English was, I don't know if she would be able to comprehend a document like that. So to protect myself, if I was going to marry her or get her to sign a prenuptial agreement, I would make sure that it's in Russian because that's the language that she's proficient in. And that's why I mentioned Swedish girl. When Barry Bonds married a Swedish girl, has to be proficient in the language that it's in. And of course, the agreement cannot be executed under fraud or undue influence, but that kind of goes without saying. So a premarital agreement is enforceable without consideration, and it cannot be unconscionable, so it has to be fair. You have to have independent legal counsel, or you have to expressly waive that requirement. You got to get a minimum of 7 days. You have to be fully informed of the effect of the agreement and the rights you're giving up, which means you ain't getting anything of my total net worth. You have to be proficient in the language, so if you're Swedish or Russian, put it in that language. No fraud or undue influence. Simple as that. So a quick summary of omitted spouse. California protects spouses from being unintentionally omitted from the estate. The omitted spouse does not take if the testator's failure to provide for her was intentional, the testator provided for her by transfer outside of the will, or the omitted spouse made a valid agreement waiving her rights to share in the decedent's estate. Unintentionally omitted family members, heavily tested topic. Make sure you understand it. And that's it.